I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome to Sovereign Citizens Hall of Fame with your boy TP. Today we are courtroom hopping back into the courtroom of Judge Joseph Lee out of the state of Kansas for the final appearance. Yes, you heard this right. For the final appearance of Mr. Isaiah Kirvin. This is the third appearance. If you have not seen the first two appearances, I highly recommend that you go see those before you watch this one, because it will all make sense once you get to this one. This is going to be our first time jumping into this and checking it out. Second time in Judge Lee's courtroom. I am interested in seeing how this thing concludes and how it all plays out. If you are familiar with Mr. Kirvin, he is definitely an aggravating individual to deal with just because of his demeanor and the way he talks. And well, you'll see if you haven't seen it already, but I recommend that you go back and watch the last two videos if you haven't. For the rest of us, we're going to go ahead and jump into this proceeding now.
State of Kansas versus Isaiah Kirvin, 24 TR 17. Would counsel state their appearances, please?
I'm here, Your Honor.
May it please the court, the state appears by Jill Gillette County.
And you're Isaiah Kirvin, correct?
Correct. Yes, I'm here.
Thank you. All right, Mr. Kirvin, there was an earlier date where you failed to appear. A warrant was issued. You were picked up on that. You posted bond. The court order was for you to appear at the sheriff's office, which you've done. We'll move on. Today was set for a pre-trial. At an earlier hearing, you had pled not guilty, or plea of not guilty had been entered on your behalf. I have reviewed the file. There was a document entitled Notice of Special Appearance by Affidavit. Mr. Kirvin, did you file that?
Yes, sir.
All right. I have reviewed that. Ms. Gillette, do you wish to make a comment on it before I rule?
I do not, Your Honor.
Very well. Mr. Kirvin, is there any brief statement that you want to make in support of your motion?
Oh, well, I want to ask a couple of questions before we get on to anything.
You can start.
Okay. Yes, I want to know what I'm going to be tried, jurisdiction I'm going to be tried under. Is it going to be civil or is it criminal?
I think we went through this before, and you're charged in the state of Kansas, and this is the Elk County District Court.
Okay.
So you are charged with operating a motor vehicle without a valid license. That is a Class B non-person misdemeanor, punishable up to 6 months in the county jail and a fine not to exceed $1,000.
Yes, I still don't understand it. I don't understand. Is that a criminal or is that a civil? Like, is that a criminal?
Well, Mr. Kirvin, I've seen these motions before. I think you well understand where you're charged and what you're charged with. So let's not fool each other here or play games, please.
No, I'm not playing any games. This so I can properly defend myself, because criminal and the civil, there are two different ways of doing things. In order to properly defend myself, I'll have to know which one am I going to be tried against.
You are charged in a traffic matter that is treated as a criminal. You would have the right, all the same rights that I mentioned earlier when I went through the rights. You would have the right to a trial by jury or court if you make the timely and appropriate motion in writing for the jury. Otherwise, it would be a bench trial. The duty would be on the state to prove you guilty beyond a reasonable doubt.
Okay. And you said it would be a criminal matter, you said?
I mentioned that already, how it's treated. It's a traffic case.
Okay, that's what I was asking, just to verify. So if it's criminal, if it's under the criminal, then it has the court grants this under Article 6 to jurisdiction under the criminal matter.
Okay, Mr. Kirvin, I have read through your motion. I disagree with your assertions of the law. Your motion is denied. We will set this matter for trial. Are you going to be representing yourself, or are you going to hire an attorney?
Well, before I go to trial, I have to know what's some questions I really have to have answered before I can enter anything, so I can properly defend myself.
I've answered the questions that are appropriate. Now, your motion and the things that you have in there, again, they're not accurate statements of law in regards to these type of proceedings. Your motion is denied. So we're going to set this matter for trial.
Okay.
I need to know if you are going to be represented yourself, or are you going to be hiring an attorney?
Can I ask what is the reason for my motion to be denied?
I've already ruled on it. It's not applicable law to this case. So, and your assertions of what the law is are inaccurate to a large degree. So
yeah,
I'm not going to go through line by line to do that.
No, I'm just trying to see to understand which ones you're referring to, so I can understand what was wrong, so I can know which one you're stating that's inaccurate, so I can have an understanding.
All right. So my question is, are you going to represent yourself, or are you going to hire an attorney?
Well, before we get to that, I have to know how to defend myself.
All right. We're going through this cycle here, and I'm not going to play the game.
No, I'm not.
Sir, be quiet.
Hmm.
You're here for a pretrial where you're not being responsive to my questions. If you want to have an attorney, you have the right to have an attorney. If you wish to be represented by counsel and if there's any risk to jail, typically there are times where there is a jail sentence that gets attached to this charge. You can apply to the court. If you meet the criteria, I'd appoint an attorney to represent you. Like I told the gentleman before you, that doesn't mean that you're going to be free. You also have a right to represent yourself. Those are the choices that you have. So you can hire an attorney, you can apply for one, or you can represent yourself. It's one of those three. Which one are you going to do?
Well, from my understanding, once jurisdiction is challenged, it's on to the plaintiff to prove the jurisdiction on the record.
That's at a trial. One of the issues that the state would have the burden of proving is that this occurred in this jurisdiction, which is Elk County, Kansas. That's a question of fact for the trier of fact.
But isn't it jurisdiction can be challenged at any time?
All right. I'm going to find that you're waiving your right to an attorney. I have requested you to answer that question numerous times. I'm going to set this. Stop interrupting. I'm going to set this matter for trial.
Before you do that, I still have I haven't answered my question. I'm trying to understand to come to a conclusion to see how I'm going to handle my case.
All right.
I'm still
you have been asking questions that are not relevant to these proceedings, and I think you're aware of that. I've seen these motions before. I've seen the people try to do exactly what you're trying to do now, where you're not going to piecemeal this out. I've answered your questions, and I'm setting this matter for trial. That would be in person at the Elk County Courthouse. Sarah, we need to have a 2-hour, stop talking. We need to have a 2-hour setting.
Well, can you correctly reflect that this court plans to bring a case against me, which it will not let me know what I'm going to be facing against? Because I'm just asking a question to get a proper understanding what's going against me. Because I'm not understanding the jurisdiction of this, which jurisdiction I'm going to be tried under. That's all I'm asking, just to get some type of clarification. That's it. I'm not playing the games. This is a serious matter. This is a court date. I came all this way to understand, to see how it's going, to properly defend myself. I'm not trying to waste your time.
Not going to argue with you about.
No, I'm not here to argue neither, Arner. I'm listening to what you're saying. I don't want to. I heard everything. It just I want to understand what's going on, and if it's how does the trial work? If I don't,
you need to be quiet now, Sarah.
I have one question.
Sarah, no, Mr. Kirvin, I told you need to be quiet now. Sarah, do you have a date for trial, please?
I have a question. If I don't want to do a trial, what's the other option?
Okay, Mr. Kirvin, I'm waiting for the clerk to give us a court date, please.
Yeah, that's fine.
Nothing further.
I'm asking
You need to.
because
Mr. Kirvin, if I have to tell you one more time, you need to be quiet. I'm going to find you in contempt.
Yes, Judge, we can do the morning of October 28th at 10 a.m.
October
Monday.
28th at 10.
Yes, sir.
Okay, our trial will be October the 28th at 10 a.m. That will be at the Elk County Elk County Courthouse. Mr. Kirvin, as I've explained to you, you have the right to be represented by an attorney. That is, if you wish to ask them questions, obviously that's appropriate to do. If you're going to represent yourself, we're going to be going with what the rules are here in Kansas, not something that you've read online or in line with what you filed. So if I strongly represent or indicate that people are better off being represented by counsel, but that's your choice. But you understand what the potential penalties are. And if you're representing yourself, you're going to be held to the same standard as an attorney in regards to being responsive and how you conduct yourself and how you present your case.
well, I was asking about my fines. If I wanted to not do the trial thing, how was a fine, or does it have to be set for a trial in order? Like, that's what I'm asking.
All right. If you're wanting to plead guilty, you can. If you want to plead no contest, where you're not pleading guilty, where you're not admitting to it, but you're also not challenging what the state has done, you have the right to do that as well.
Yeah, that's why I was saying I wasn't challenged. I was just understand. So how much is the fees or whatever once that's settled, would that take care of everything? And I'll need to know like the amounts for whatever it is.
Well, I have told you what the maximum penalties are. I don't negotiate with people. I don't tell them what the sentence is in advance. I'm required to tell people what the maximum penalties are.
Okay, so you said the penalty was jail time, but you didn't say the cost.
I said that I said that on a Class B misdemeanor, which this is, the punishment is up to 6 months in the county jail and a fine not to exceed $1,000. Court costs on this type of case are $108. There can be other things that are assessed as well. If a person was taken into custody, generally there's a processing fee of $45. Additionally, if somebody is found guilty, if they're placed on probation, there's a fee that goes along with that. There's various things that occur with that. But as far as the penalty section, I've advised you what the maximum penalties are.
Okay, so for the fees will be like you said like 1,000 and then about 40, so like about almost
I said that the maximum penalty is 6 months in the county jail and a fine not to exceed $1,000.
Okay, so do you have a number for me so I can see if I'm able to pay to see how much I would if I can even.
Okay, Mr. Kirvin, what you're doing is asking me to give the sentence before you pled guilty. We don't do that. I've explained that.
If I do the no contents is what so I'm not arguing with you, I'm just if you said no contents is not an argument. So if I do no contents, what am I looking towards?
No contest. It's the same penalty. A no contest, you're not challenging what happened. What happens then is we ask for the state to proffer what their evidence would be. That means they make a statement to the court. If the factual basis that they recite, if that was their evidence at trial, then a person is found guilty. It's not a situation where you get to contest that. If you're wanting to contest what the charge is, that's what a trial is.
Okay, yeah, that's why if I want to do the no contents, I want to see what the state would have to say. That's what I'm trying to see if we can take care of this and resolve this, because I'm not arguing with the courts.
All right. Have you been in contact with the county attorney's office prior to the court proceeding?
No, just today, just right now. I believe I sent a copy of my documents, but I haven't spoke to them anything about anything else.
All right. The court is not a part of any negotiations that can occur between the person charged and the county attorney's office. Ms. Gillette, are you willing to speak with him if I call a brief recess?
Sure.
I didn't hear your response, Ms. Gillette.
Sure. Yes. Sure.
Okay. Okay, Mr. Kirvin, if you want to speak with the county attorney about what her recommendations would be, I'm going to do what they call a breakout. And so we'll be putting this case on pause. They'll on the screen will ask for the person to click it for the breakout room. Then you have, that's basically a private conversation with whoever's there in the room with you and then the county attorney. It's not being broadcast out. It's not something that I hear. So I'll grant a brief continuance and we'll be in recess for that. And if the clerk would do the breakout room, please.
Okay.
All right. Record will reflect that the record will reflect that both the defendant and the state have returned from the breakout room. So we have the same appearances as before. Mr. Kirvin, did you get an opportunity to speak with Ms. Gillette?
Yes, we spoke, and I believe we came up to an agreement.
All right. Ms. Gillette, is that correct?
Yes, Your Honor.
And what's the agreement as you understand it?
He's going to plead no contest to driving without a driver's license. And my recommendations are going to be a $100 fine, court costs, no jail sentence, pay in 60 days. And that if he doesn't pay, his license would be suspended. He does have a cash bond that he paid cash. He would consent to any fines and costs being taken from his cash bond. There's a form he'll need to sign at the county district court office over here, and then any difference would be refunded to him. So he does have the money here, and it will be paid out of the cash bond he has on file. I did look up; I believe it is a cash bond, and the difference would be refunded to him. Those are going to be my recommendations.
Okay, so you're recommending a $100 fine and court costs, is that correct?
Correct, Your Honor.
All right. Mr. Kirvin, is that your understanding of the agreement?
Yes, sir.
Okay. Mr. Kirvin, you need to understand, like I mentioned before, the court is not part of the plea negotiation process. So I'm not bound to follow the recommendations that the parties make, even when they've agreed to it. The court could sentence you to the maximum that I told you. I'm not saying that's what I'm going to do, but you need to understand that legally is possible.
Yes, sir.
Okay. With that in mind, is that correct? You still wish to proceed with a no contest plea?
Correct.
All right. Do you understand that with a no contest plea, you'd be waiving your right to a trial?
Correct.
And has anybody forced or coerced you in some fashion to make this decision?
No, sir.
Very well. Ms. Gillette, what would the state's evidence be if this matter were tried?
Yeah, the defendant was driving home from Greenwood County. He had a case up there, and as he was driving home, he was stopped here in Elk County. They did not know that he had been in court up at Greenwood. He was stopped by Deputy Mike Nelson on February 6, 24 at 3:30 p.m. on Highway 160 and 99 Junction. He was driving a 2007 BMW with a Texas plate. He had no driver's license. I don't know if he just hasn't renewed it and it's expired. Oh yeah, I do. It was expired. And he has not renewed his license. So his license is considered expired. So he had no DL, and we charged him under 8-235.
All right. I do find that there has been a factual basis that support the charge. And I do find the defendant guilty on his no contest plea. We'll proceed at this time to sentencing. Does the state have any additional statements that you wish to make?
No, Judge, just the fine court costs and apply his bond and refund the difference.
All right. Mr. Kirvin, are there any statements you'd like to make before I pronounce sentence?
No, sir.
Okay, Mr. Kirvin, do you have your driver's license now?
It's just an occupational license that I used to go back and forth from work, but not an actual license. It's just like kind of like a work permit type of thing. And but I'm not driving. I came here with my family member to bring me here to come to this court.
Okay. I'm not familiar with, is it Coolidge, Texas that you live?
Yeah, I'm in San Antonio now, but that's where I was staying at before.
Okay. All right. Texas requires a driver's license. And Kansas and Texas are a lot like each other in the sense that most people to get to and from work and so forth need to be able to drive. I strongly encourage you to get a proper driver's license. I'm going to pronounce sentence now. I'm going to impose a $100 fine, and I'm going to assess court costs in the amount of $108, which is the statutory amount. I've considered giving you a jail sentence. I'm declining to do so. So there's not a jail sentence imposed. However, I am going to require that this be paid. And you have cash bond that's here in Elk County, or did you post that down in San Antonio?
It was Republic. It's in Kansas where I got picked up. I think it's Republic County or somewhere where I bailed out there.
Let me check with the clerk in a minute and see if they've got that transferred up here now. Sarah, can you answer, is there a cash bond on hand for Mr. Kirvin?
Yes, sir. We do have a cash bond posted for him.
And is it in excess of $208?
Yes, sir. It was 2,500.
All right. Okay, so Mr. Kirvin, following this hearing, I'm going to order that you pay that today. You have the cash bond on hand. You can come over to the clerk of the district court. They've got some paperwork for you to do in regards to that. So you'll be paying the $208. They'll be refunding the other funds to you, and that will complete this case. Again, I strongly encourage you to get a driver's license. You're a young man still. I'm sure you're going to need one for work and various things. And the vehicle apparently was properly tagged. This isn't a case where a lot of times some of these things we don't have a tag and there's no insurance, and you're not charged with those. So I'm assuming you had those things. But you can really get yourself in a bind if you keep accumulating these type of charges. And most states will generate a license for you and then suspend it, and in Kansas, I can't speak for Texas, but in Kansas, there's some mandatory jail time on driving while suspended. So, for your benefit, I'd strongly encourage you to get a valid driver's license. This matter is adjourned and the parties are free to go. Thank you.
Well, guys, we have come to the end of this proceeding. Listen, I'm going to be honest with you. I didn't see this thing playing out the way it did. But as we can see, he tried it for a little while. This time, instead of going into the common law and admiralty law, now he starts talking about civil law. But, it's right back to this is criminal law. And we see that Judge Lee was like, listen, this is not going to prolong. We're not going to drag this out. Be quiet. I'm not having it. Shut him down a couple times. And what I realized is once Mr. Kirvin realized that, Judge Lee wasn't having it and he wasn't playing, this was going to trial one way or another, he was like, listen, let's make a deal. Let's talk a deal. So he knew the jig was up. He knew that he was playing games. He knew exactly what he was doing, because once he saw that he wasn't going to be able to prolong this thing, then all of a sudden he starts talking deal. And as we can see, The prosecutor recommended what she recommended after they went into the breakout room together, and the judge pretty much went along with the prosecutor's recommendations, but he strongly advised Mr. Kirvin to get that license. And I thought that the judge was very sincere in his talk with Mr. Kirvin. So, I appreciate that, because I know it had to be aggravating dealing with this guy with all of the nonsense, the rhetoric, the back and forth. But yet, the judge didn't allow it to become personal, to where he gave him jail time because of that, because he said he thought about giving him jail time just because of the charges and what the jail time that could possibly be sentenced on the case. But we noticed that it didn't seem like Judge Lee took this thing personal, and it's probably because he's been dealing with these type of individuals for so long and dealing with this type of stuff. So with that being said, as you guys can see, I'm in the car once again at work, but I wanted to definitely get this done. Got the little ear pods in and everything. But yeah, I appreciate you guys, man, always for joining me. We're going to keep these videos going. Once again, this is Sovereign Citizens Hall of Fame. I appreciate you guys joining me. And with that being said, guys, court is adjourned. See you guys soon.